Yes, two matters for inclusion under the hearing.
Inclusion in the list.
Under the heading hearing. Joshua determination in respect of classification.
It's with Justice Same mentioned before. You have been sitting in my court every day. You know it. Why are you doing this?
No, one is municipal matter.
Well, may I permit to mention one matter from courtroom number 759. My lord, the urgency is that
Look in my list.
yes, my lord, determination is your lordship. My lord, Justice Rajashri Bhadwaj.
Yes, tell me.
My sir, urgency is that my CSC Limited, my lord, disconnected my electricity line. Therefore, I filed the.
When did they disconnect?
My lord, 2 days back, my lord.
Yes.
Therefore, I am praying for a listing of this matter before your lordship.
2 days back they have disconnected.
My lord.
On what ground? What ground?
A non-payment of the outstanding dues.
Non-payment of, go to, you know where to go? GRO.
Yes, my lord.
Go there. Why are you mentioning here?
No, I already filed a writ petition, my lord, there.
Withdraw the writ petition, go there. Otherwise, I'll pass the same order. You want me to take it? I'll take it up Monday. I'll dismiss it.
I will apply here. Grateful.
Yes, call out the list.
Last occasion, my lord directed petitioner to soft copy upon Advocate General. My right friend.
I am from the state lordship.
Which item? One second.
No recording. Only.
Ghulam Muhammad. Okay. Where is the? Yes, where is the petitioner? You appear for the petitioner?
No, I am from the state lordship.
State.
For the state.
I'm on the
Where is the
private.
petitioner?
Petitioner is not here.
We'll pass it over. Let him come.
Lordship kindly fixed on Wednesday.
List on
Wednesday.
Wednesday.
Then my monthly list of April, my lord.
Lordship, I am for the petitioner, Lordship. Led by Mr. Huda, Lordship. He is engaged in court number, Lordship. Kindly keep it next week, Lordship. I have served.
Wednesday. You be here on Wednesday. The speaking order which you have passed is not correct. You have not taken into consideration lot of observations of the court.
Wednesday, Lordship. Obliged.
Get, madam.
May I please, your lordship?
And for the respondent number 1 and 2.
You appear for the ombudsman.
The ombudsman, basically WBERC, my lord, commission, my lord.
But this matter was heard elaborately on the last occasion.
Yes, yes. This is where you had acted on the advice of the.
Yes, yes. Now, lordship, before going into the other aspect, I am drawing your lordship kind attention to the factual aspect what has been stated in the writ petition. Thereafter, I will reiterate the point of loss. Now, lordship, kindly come to paragraph 4 onwards. At page 5, lordship.
Yes.
Two. May I place it?
Yes.
May I place it, lordship? But the service of the respondent number 4, that is a private respondent, which was situated at Dankuni, Hooghly, was disconnected on 13/4/2023 as per memo number such and such issued by the respondent number 3. Respondent number 3 is the Pollution Control Board, lordship. Herein on the ground of violation of plastic waste management rule, which was framed under the Environmental Protection Act. The direction was issued under section 33 capital A of the Water Prevention and Control of Pollution Act, section 31A of the Air Prevention Control Act, the environment, all are perimeter section. That section 5, which I have already cited before your lordship on the last occasion, that is notwithstanding contained in any other law, that we are bound, duty bound to comply with the direction given by the officials. Now, on that basis, the environment and rule frame thereunder. Section 5, that what I have cited on the last slide. Environment specified that whenever any direction is given by the concerned authority of the Pollution Control Board, then the electricity authority amongst others are bound to obey the same. Such notice was notified inter alia to the petitioner as well as to the private respondent. Now I am drawing your lordship kind attention, though I have already drawn your lordship kind attention on the last occasion, but to reiterate my submission, your lordship kindly come to page 17. Lordship got that? Lordship kindly take a note on that. This is the closure order with disconnection of electricity, which has been issued by the respondent number 3, lordship. And here, in the pretext of this closure order, it has been notified. Lordship kindly turn to page 18. Number 1, that is the respondent number 1.
Even 17, third paragraph from the bottom.
Yes. I'm deeply obliged, lordship. It has already specified in the 3rd paragraph for disconnection of the electricity. Now here it has been notified to the, first of all, lordship kindly take a note on that, first to the private respondent as well as to the petitioner before lordship, that is the authority. Now, if your lordship kindly see the section 5,
Section 5 of
the Environmental Protection Act. Lordship, I have already given to your lordship on the last occasion. Filer মধ্যে আছে তো দেখো।
Yes.
On the last occasion, I have cited certain judgment as well as regulation. Well, এই রেগুলেশনটা একটু বার করে রাখবেন আর ইলেকট্রিসিটি একটা একটু দেবেন, হ্যাঁ। The Environmental Protection Act. Lordship, kindly come to section 5.
Yes.
Power to give directions. Now, notwithstanding anything, Lordship got that? Notwithstanding anything contained in any other law, but subject to the provision of this act, the central government may, in the exercise of its power and performance of its function under this act, issue directions in writing to any person, officer, or any authority, and such person, officer, or authority shall be bound to comply with their direction. Kindly note on that. Kindly take a note on that, that any person or authority, lordship. And we are bound to comply with the direction given by the authority. And for the avoidance of doubt, it is hereby declared that the power to issue direction under this section includes the power to direct the closure, prohibition, or regulation of any industry, operation, or process. Or the second point, lordship, that is on next page, stoppage or regulation of supply of electricity or water or any other service. Now, on that pretext, we have not received any letter from the side of the private respondent that they have preferred any appeal under section 5 capital A. So on that basis, we have complied with the directions as passed by the authority under the umbrella of section 5 of the Environmental Protection Act and other acts, lordship. Now, on the last occasion, I have drawn your lordship kind attention to the Supreme Court decisions of the notwithstanding, assertion of notwithstanding. Now, lordship, before going into the judgment, let us highlight on the factual aspect. Now, lordship, kindly come to page 19. Lordship got that? Here, the letter has been issued, this order has been issued on 9/6/2023, and we have stated in the paragraph that we have received this order on 16/6/2023. Now, in paragraph 5, I have already stated that disconnection has been made on 13/4/2023, page 5, lordship. On the pretext of the direction, the disconnection has been made, page 5, paragraph 5.
Yes.
13/4/2023. Now, lordship, kindly turn to next page 6. The respondent number 3 again issued notice to the petitioner and others, including the private respondent, for withdrawal and or suspension of the earlier order dated 11/4/2023 by memo number such and such dated 9/6/2023, which was received by the petitioner on 16/6/2023. And on the very day, as per the direction of the respondent, the petitioner reconnected the electric line of the private respondent. There is no dispute on that. We have already reconnected the line on the day when we have received that notice, suspension notice. Now, Lordship, kindly come to page 17, which I'm standing at page 19, Lordship. This is the closure order with restoration of electricity. In due consideration of the prior data submitted by SL hereinafter located at Dankuni Commercial Complex, district such and such, for suspension of the order for closure with disconnection of electricity issued by the West Bengal Pollution Control Board, hereinafter referred to as the State Board, against the unit, and the report of inspection conducted by the State Board official on 8/5/2023, which revealed that the unit was not in operation and the electric connection was disconnected. The State Board is hereby pleased to suspend the order for closure with a disconnection. It is issued by SL Kitchenware, that is a private respondent, located at Dankuni Complex, white memo number dated 11/4/2000, with the following direction: that unit shall always operate maintaining all environmental norm, including plastic management rules such and such. That unit shall remove the machine for production of bands SUP item for the pin. The electric connection of the unit is ordered to be restored with immediate effect. So in pursuance to the directions, we are duty bound to comply with the direction. We immediately reconnected the line on 16/4/2020, the day when you have received this order. Now, Lordship, kindly turn to next page, page 21. Now, in the interregnum period, Lordship, we have issued the bills as per the regulations that I have cited on the last occasion. Then again, I will reiterate on regulation as per regulation 48 as well as regulation 55. Now, kindly come to paragraph paragraph 7, Lordship, page 6. Paragraph 7. Now, what are the laws on the basis of which we have issued the average consumption of bill? The petitioner, as per clause 4.10 of regulation 55, read with, it should be read as clause 4.10, wrongly written 4.18, of the regulation 48 of the West Bengal electricity regulation. The bill was raised for the month of May such and such and June. The private respondent filed complaint protesting the raising of energy bill and June before the concerned authority. The concerned authority replied to the complaint under complaint number such and such to the private respondent on 13/6/2023. But this is the complaint annexure P3, Lordship, got that? This is the complaint raised by the private respondent. And on that basis, the reply has been given at page 22. As per the above memo, this is to inform you that the line was temporarily disconnected on 13/4/2023 as per memo number such and such of the Chief Engineer WBSP. It is also to inform you that the bill for the month of May has been preferred as per guideline of the WBRC. That is the regulation 48 and regulation 55. So the review of the bill for the month of May cannot be considered, and hence you are requested to pay the bill in time. Now, he was aggrieved. In page 23 and 24, we have raised the average consumption bill. He has aggrieved and he preferred an appeal before they made an application before the concerned GRO. Now, there is a specific provision which your Lordship knows. When there is a dispute, the matter is to be referred to the GRO. Yes. Now, on that basis, he has made an application before the concerned GRO, and the GRO passed the final order, annexure P4. That is starting, this is the forwarding letter at page 25, and the next page, page 26, Lordship. But this is the submission which has been given by the petitioner. May I place it? starting the unit of Messrs. SL Kitchenware, the petitioner is situated and such place. Nankuni consumer is engaged in manufacturing and export of the expanded polyethylene foam product used for packaging items, cellular, polythene, sheet, roll, such and such, and full. In this connection, copy of the consent to operate such activity issued by the West Bengal Pollution Control Board, certificate for such activity for overseas buyer and such and such. The petitioner is engaged to develop biodegradable plastical product and also connected with Symphony Environmental US Biogreen such as such. This the fact has been referred. The petitioner has invested substantial for manufacturing bleach pulp. The petitioner is a bona fide consumer of WBACDCL, paragraph 4, having contract demand of 300 kVA. He is a bulk consumer, 300 kVA, enjoying electricity connection in the said unit for last few decades without any allegation and dispute then, and have been paying bill regularly, and then and even at the time of pending situation, the regularly paid the bill without fail to the production of manufacturing such and such. Next, Lordship, kindly come to page 20. All the working activities, production and menu process at the said petition have been continued lawfully. And then paragraph 6, here it is that on 13/4/2020 at 6:30 PM, without giving any notice, some men of WBCL came to the said unit and suddenly disconnection of supply without giving any approval for making necessary and shutting down the ethos such and such has been given. The paragraph 7, that the said sudden are violating the Electricity Act. From where we have violated the Electricity Act, that has to be satisfied by my learned friend. I have already stated, but I will reiterate. And the regulation not cause damage to the running machine and apparatus, but also cause risk of devastating fire, danger property. However, the petitioner was fortunately able to manage and control such things that the acts of sudden risk endangering human life, product committed such and such in nothing but illegal afterthought concocted, and in the result showing supremacy and musical such. But these are the fact which has been laid down, where no provision has been laid down by my learned friend client, from where we have violated the statutory provision and we have disconnected the line. Now, on that basis, there was a submission of the licensee. Kindly turn to page 28. Lordship, got that? Page 28. Messrs. SL Kitchen Limited is a centralized bulk consumer having consumer and contractual demand such and such. The said services was disconnected on 13 as per memo number of the Chief Engineer WBPCB, that is the Pollution Control Board, due to violation of plastic management rules and its amendment and notification of Department Environmental such and such. The said service reconnected on 16/6/2023 of the Chief Manager, which was received by the concerned through mail on 16/6/2023. As the line was temporarily disconnected on 13/4/2000 and reconnected on 16/6/2000. So as per WBRC notification, that is the notification 55, clause 4.10 and notification 48, clause 4. The bill raised for the month of May 2020 and June 2020. On the complaint letter, this office replied memo number dated as the bill are raised according to WBRC norms and disconnected was made as per the clause stated under serial number. So no question of compensation. Hence the notice issued under section 56(1) of the for non-payment of monthly and bill is valid. Now kindly come to the observation made by the GRO. This is very important. From the submission and counter submission, both the parties, it appeared the petitioner mainly demanded the disconnection order done by the licensee is wrongful. And for such disconnection, the petitioner have faced a huge financial loss to the tune of rupees 12.50 crore. Therefore, the petitioner is entitled to receive compensation of rupees 500 per day for the entire period of disconnection in addition to other compensation payable for wrongful disconnection of electricity payable as per regulatory mandate applicable in this case. Petitioner further demanded to waive the bills for the monthly bills of May 2023 and June 2023 by cancelling, setting aside the illegal assessment made therein. The petitioner also demanded to quash the notice of disconnection of electricity dated 14/6/2023 immediately. On the other hand, the licensee has stated that the temporary disconnection was made on 13/4/2023 and reconnected on 16/6. So as per WERC notification number 4.10 of 55 WBRC and 4.10 of 48 WBRC, bill was raised for the month of May 2023 and June 2023. Accordingly, licensee further stated as the bill are raised according to the WBRC norm and the disconnection was made as per the clause stated in serial number 2 of the submission. So the question of compensation may not be allowed. In support of this disconnection, licenses submitted one copy of the order of the Chief Engineer, Executive Cell, West Bengal Pollution Control Board, wherein it is stated that this direction has been issued to the officer in charge, Dankuni Police Station, and Director WBASC in conformity with the order of the Honorable High Court, Calcutta, dated 21/8/1998 and 28/4/1999 respectively. It further appears that disconnection has been happened on the basis of the direction of the West Bengal Pollution Control Board, where WBSCL has nothing to do except disconnection of the above connection. Licensee referred clause 4.10 of 48 WSC, where it is stated, notwithstanding anything to the clause has been here reiterated, Lordship. That is, notwithstanding anything to the contrary contained in anywhere in this regulation, in case where no consumption has taken place for a reason whatsoever, including disconnection of supply due to the fault on the part of the consumer, but excluding instances of interruption in supply due to failure on the part of licensee, the fixed charge or demand charge of a consumer, as the case may be, shall be calculated on the basis of contract demand. And also serial number 4.10 of 55 WSC, it is stated, notwithstanding anything contained contrary elsewhere in any manner in other regulation, the commission during disconnection period, for any reason whatsoever, but prior to termination of supply agreement of termination agreement, the consumer is liable to pay the meter rent, minimum charge, and fixed charge or demand charge as per applicable. On going through the entire document as submitted by both the parties, it further appeared the connection of the petitioner was disconnected in terms of the order such and such dated 9/6/2023 of the Chief Engineer, Operation and Executive Pollution Control Board, and the direction was issued in exercise of power conferred under the provision section 33 capital A, 31 capital A, the Environmental Protection Act, and the rule framed thereunder, after being approved by the competent authority. Hence, on verification of the bill of the petitioner, it is noticed that the bill raised by the licensee is in terms of the regulation as mentioned by the licensee in their submission accordingly. On the other hand, petitioners stand on their argument that Regulation 4855 nor any provisions provide any procedure for assessment on the basis of contract demand during the period when the electricity was disconnected by the wrong advice given by the Pollution Control Board under mistake belief, where there was no fault on the part of the petitioner. The said assessment is based on falsity, surmises, and conjecture, baseless and merit-less illegal assumption, and made with an interest to extort money from the petitioner through illegal means. It is also noticed in this case, it is definitely not the duty of the licensee of the W to verify. Lordship, kindly take note on that. This is the penultimate paragraph. It is notified that in the case that it is definitely not the duty of the licensee, that is the WB, to verify the order of WPCB, whether it is right or wrong. On the other hand, it is the duty of the licensee WA to maintain, carry out the order of the West Bengal Pollution Control Board, as noted above in the observation. It is further noticed that the bill raised by the licensee is proper and in terms of regulation WBRC. Hence, the compensation as demanded by the petitioner is rejected, and the both parties are further given over to submit their views within 10 days from the date of issue of this order. If no views expressed received from the either of the parties, the draft settlement order will be treated as final order. Now, kindly come to page 30. Upon receiving the draft settlement order of the CGRO, the petitioner, Mr. S.L. Kitchener, has submitted their view, which is nothing but the repeat of their earlier submission, which has already been recorded in the DSO dated, DSO means draft settlement order, DSO dated 15/9/2000. Hence, the draft settlement order is considered as a final order and the case is hereby disposed of. So, the concerned GRO found that there is no illegality on the part of the WBCDCL. WBCDCL has, while considering the direction under Section 5 of the Environmental Act, has complied with the order, and this bill has been raised within the framework of the statute as per the Regulation 55 as well as Regulation 48. Now, against that order, they have preferred an appeal before the concerned ombudsman. Now, in the ombudsman, Lordship, kindly take out what we have stated before the ombudsman, page 31, Lordship. The following points submitted before the in respect of the interim order dated 23/4/2024 on the above subject and reference. With regard to paragraph 2 of the order dated 23/4/2024, London, it is submitted that notice is required to be served before disconnection of the reason details in section 56 of the Electricity Act and clause 4.3 of the WBSC 55. The reason for disconnection, on the last occasion I have stated before your lordship what are the mode of disconnections and on what basis this disconnection can be made by the authority and when the notice can be issued within the framework of the statute. Lordship knows under section 56, when there is a non-payment of the outstanding due, only then 15 clear notice days should be issued, and apart from that there is no provision in the statute where the notice is to be issued apart from deemed termination or the disconnection made on his request. If they are required, then the notice can be issued. Otherwise, there is no provision in the statute where notice can be issued. I have already stated before your lordship that an ordinary person can do anything unless prohibited by law. I will fortify by decision. But a statutory authority cannot do anything unless provided in the statute. Now, here it has been specified. Now, subsequently, another reply has been given, page 33.
Yes.
With regard to paragraph 5 of such and the land, it is submitted the in terms of clause number 5. It should be section 5, lordship. Here clause 5 has been dated of the Environmental Protection Act, where it stated notwithstanding this has been reiterated. Notwithstanding anything containing any other law but subject to the provision, the central government may at the exercise of the performance function under the issue direction in writing to any person or any authority, and such officer or authority shall be bound to comply with such direction. Now, this has been already stated before the concerned authority. Now, what is the order passed by the concerned ombudsman? Your lordship kindly turn to page
Final.
42, final order, because draft settlement order given and it has been culminated into the final order, lordship. That's why I have not placed this draft settlement order. Which is the subject matter of challenge before your lordship. The complainant has approached this forum regarding the settlement of billing dispute for the month of May and June 2023, compensation for wrongful disconnection, and to raise monthly electricity bill as per actual consumption. The petitioner approached London CGRO on 15/9/2023, who after conducting necessary hearing passed final order on 4/10/2023. Not being satisfied with the order passed by London CGRO, the aggrieved petitioner approached this forum for redressal of this grievance. The grievance petition such and such, the complaint was forwarded to the chief engineer, customer of cell, the OP, with a request to submit the factual submit report in respect of grievance of the complaint to the authority with a copy to the concerned appeal petitioner. The said chief engineer, CRM cell, submitted the proper report such and such, which was considered as the report of the OP. At the outset, AP in the submission state the licensee has arbitrarily disconnected. AP means the private respondent. The electricity on 13/4/2010 and again reconnected on 15/6. It is reconnected on 16/6. Here it has been written 15/6. No disconnection notice stating the reason whatsoever has been served upon the consumer before such disconnection, and to their great surprise, subsequent electricity bill amounting to 1,35,555 for the month of May 2023 and amounting to 1,39,917 for the June 2023. Total 2,75,470 have been sent to the consumer. Besides, the licensee refuses to provide separate electric bill and rather incorporate the charges for disconnected period during which there was no consumption plus the charges for the period after reconnection. Hence, the AP prays for waiving of fixed demand charge during the disconnected period, as the disconnection was issued without any fault of the consumer and without any prior disconnection notice served upon the consumer. The OP in his submission state that the disconnection and subsequent reconnection after the gap of 62 days has been done as per official instruction of the West Bengal Pollution Control Board. When asked whether the instruction of WPCC give the licensee the right to disconnect the consumer without serving any prior notice in consideration of 4.3.1 and 4.3.14 regulation dated ATO, the licensee prefers 7 days to time to produce the necessary order. On the basis of submission of both the parties, parties, it is held that 7 days time to be given to like to produce the necessary paper in this regard, and thereafter matter will be heard again. So it was ordered the licensee shall submit the necessary paper such and such and certified copy. Subsequently, the case was taken on 23/4, paragraph 9, 23/4, 2000 in presence of both the parties, and order was issued. Now these are the presence are recorded. Now paragraph 11 and paragraph 12, Lordship. Lordship, kindly come to paragraph 12 of this order. On the basis of submitted document from both the parties during the course of hearing, it is emerged that main point for consideration in particular case is number 1, whether the direction of WBPCB gives the licensee the right to disconnect the electricity of the consumer without serving any prior disconnection notice. Number 2, whether the consumer is liable to fixed demand charge when the disconnection has been done without any fault on the part of the consumer. Whether the AP is eligible to get compensation for a period of wrongful disconnection. Again, the licensee sought for time to produce necessary in this regard to justify their action without serving any prior notice for disconnection. Subsequently, next page, Lordship. Subsequently, the licensee in the submission on 29/4/2000 state that the situation reason like disconnection as per the PCB has not discarded neither in the WBSC regulation, and further state that Section 5 of the 1986 Act empowered PCB to issue direction including stoppage of supply of electricity, water, or any unit, and the respiratory are bound to comply such direction, and hence to comply PCB direction line was disconnected and no previous notice was required for such direction. These forum category seeks the provision or direction which empowers the licensee to disconnect without serving any notice. But the licensee failed to produce any such document as sought for. The licensee has violated the process of disconnection by not serving disconnection notice. But there is no specific provision where notice has to be served for disconnection in case where the direction has been given by the authority and the order which has been passed by the authority already notified the petitioner as well as the authority. The direction of PC have nowhere asked the licensee to disconnect the electricity without serving any disconnection notice. Hence, it is held that since this is a wrongful disconnection and therefore cannot demand any fixed charge during the period, besides, AP is also entitled to get the necessary as admissible under provision of clause 15D as amended during the period of wrongful disconnection. So, it is ordered that as per regulation such and such, shall waive the no demand charge as claimed, that as per provision principal shall pay the compensation during the wrongful disconnection. The case is thus disposed of. Now, this has been already, this order has already been continued. That is the same order which has been passed. Now, Lordship, kindly come.
So you're challenging both the compensation as well as
this compensation as well as the order passed by the ombudsman that the disconnection has been made without any notice. These two things which we have challenged.
the final order in terms of fixing the charges for the month of May and June.
Lordship.
So that also you're challenging?
Yes, yes.
That you are entitled,
In
or you
entirety,
are empowered to raise
the bill
the bill.
within the ambit of in the four corners of the statute, Lordship. Now, Lordship, now let us see the point of law. Now, on the last occasion, I have already stated before your Lordship about the Section 5. Just now I have already read, so I don't want to waste the valuable time of this court. Now, so far, first of all, let us see the notwithstanding clause, Lordship. This notwithstanding clause, on the last occasion, I have cited one decision. Probably it will be on the record before your Lordship.
Let me see.
That is AI 2005 Supreme Court 514, where Lordship kindly come to paragraph 32, starting from page 522. The paragraph 32 start from 521 from the bottom, and about the non-obstinate clause, it has been specified. In such and such case, reported in Supreme Court, paragraph 67, observe that in the context of construction of a non-obstinate clause, that is the notwithstanding, a clause beginning with the expression notwithstanding anything contained in any other act or in some particular provision in the act or in some particular act or in any other law for the time being in force or in any contract is of more often than not appended to a section in the beginning with a view to give the enacting part of this section in a case of conflict and overriding effect. Lordship, kindly take note on that. overriding effect over the provision of the act or the contract mentioned in the non-obstant clause. It is equivalent to saying that in spite of the provision of the act or any other act mentioned in the non-obstant clause or any other contract document, then it will be have the full operation or that provision embraced in the would not be impediment for an operation of the enactment. So my humble submission before your lordship, when non-obstinate clause is there, it will override any of the provision, either of the same act or of the any other act, provided either of the Electricity Act or in any other statute. Apart from that, in the Electricity Act, neither of the provision which has been stated by in the ombudsman order that where notice has to be given when the direction has been given by the authority for disconnection. This is AR 2005 514 paragraph 32. Enter some judgment has been laid down. So lordship, I am not reading out in verbatim. Now next part, your lordship kindly see the decision which I am referring. Now I have already stated before your lordship that a statutory authority, that is the ombudsman, is also the statutory authority which has been considered under section 42 subsection 5 and 6. And lordship, I am drawing your lordship kind attention to the Electricity Act for the time being. Section 57. Electricity Act. Lordship got that Electricity Act.
Yes.
Section 57, lordship.
Yes.
The subsection 1, which provides the appropriate commission may, after consultation with the licensee and person likely to be affected, specify the standard of performance of a licensee or a class of licensee. That regulation which I have cited before your lordship, where standard of performance has been laid down, where it has been held when the disconnection can be made, when notice has to be issued, that I have drawn your lordship kind attention. I will again draw your lordship attention. Now, if a licensee failed to meet the standards specified in subsection 1 without prejudice to any penalty which may be imposed or prosecution be initiated, he shall be liable to pay such compensation to the person affected as may be determined by the appropriate commission, provided that before determination the concerned shall give a reasonable opportunity of being heard. The compensation determined substance shall be paid by the concerned within 90 days. Now, as per section 57, where the act clearly specifies that the standard of performance must be laid down, and if the authority or the electricity authority act beyond the standard of performance, only then the ombudsman has got the power to grant compensation. Now, lordship, kindly come to regulation. Regulation 46. Hey, regulation take to
You
the
lordship may kindly take up these regulations. It's a bunch of regulations, my lord. May
what are
help in the subsequent proceedings also. There are so many regulations.
Yes.
The index also.
Thank you. Yes.
Regulation 46. On the last occasion, I have already cited. Again, I am saying, lordship, kindly take note on that. Regulation 46, I am drawing your lordship kind attention to page 19, clause 14. Page 19. 19 Regulation 46.
It's running page 19 also. In this part.
Yes. Enforcement.
Enforcement mechanism. In the enforcement mechanism 14.2, lordship, kindly see. any consumer intending, first is the when the complaint can be raised. Then 14 point, any consumer intending who is affected by any failure of licensee. Lordship, kindly take note on that. To meet the standard of performance specified in this regulation may submit a complaint to the grievance redressal officer in the matter of the said failure of performance, excluding the case of section. Regarding the theft of case, the ombudsman has got no power. Of that, a consumer and intent consumer may also submit an application to the grievance redressal officer concerned of the licensee claiming compensation for such failure and also for delay in incursion with reference to the time limit specified in the supply court or of any competent court of law. The grievance redressal officer, after receiving such complaint, shall dispose of the same as per the regulation such and such under section 42. Now, the grievance redressal officer has specified, no, there is no violations, and he has acted, the authority has acted within the framework of the statute, and the bill has been raised within the framework of the statute. And at this date, since the direction has to be complied with by the authority and duty bound to comply with the direction, so no notice is necessary. So if the effector intending the is not satisfied the order of grievance redressal officer or does not receive any order from the grievance redressal whom he has approached within the time frame under subsection 5 and 7 of 42 of the Act, he may submit a written representation to the ombudsman. Now, he has, under this provision, he has exercised that power under 14.3. Now, the ombudsman has passed this order contrary to the observation passed by the GRO, that this is the subject matter of challenge. Now, Lordship, kindly see when the disconnection can be made. I have drawn your Lordship kind attention to section 56 on the last occasion of the Electricity Act.
Yes.
Disconnection of supply in default of payment. Lordship, got that?
Yes.
Where any person neglect to pay any charge of electricity or any sum other than a charge for electricity due from him to a licensee or the generating company in respect of supply, the transmission or distribution or wheeling of electricity to him, the licensee or the generating company may, after giving not less than 15 clear days notice in writing. So when the notice has to be issued, when there is a non-payment of the outstanding dues. Statute clearly provides that. Where the statute clearly provides, emulates, where the notice has to be issued when there is a non-payment of the outstanding dues. This is not the case where there is a non-payment of outstanding dues. Now, next part, your Lordship knows that under section 126, assessment can be made, and under section 135 of the Electricity Act, disconnection can be made, where no notice is necessary in case of theft of electricity or unauthorized use of electricity. Apart from that, when the disconnection can be made, I'm drawing your Lordship kind attention to regulation 55. Lordship, kindly come to page 15 of the regulation 55.
Starts from page 68.
68.
Starts from 68.
Yes.
Page 15.
Running page would be? Yeah, which regulation is a
Regulation 55, Lordship, clause 4, page 15. Page 15.
It's
disconnection for non-payment?
Disconnection.
Disconnection of supply.
Disconnection of supply, where mode has been specified when disconnection can be made. The first instance is that disconnection for non-payment. Here, the statute clearly provide notice has been issued, has to be issued, Lordship. The licensee shall issue a disconnection notice. Lordship, got that? First line is there. Under section 56(1) of that, through the bill against the electric consumption such and such, where the following issue shall be specifically mentioned. So here it has been specified when disconnection has to be made for non-payment of electricity bill, only then notice has to be issued under section 56. Now, this is the first mode. Second mode is, Lordship, kindly come to turn to next page. Kindly take pen to turn to next page. That is page 16. Disconnection for theft or unauthorized use of electricity. 4.2. Lordship, got that?
Yes.
Third instance, this so first instance is disconnection for non-payment of electricity bill, where the statute provides it is mandatory to issue notice prior to disconnection. And second is the disconnection for theft of unauthorized use of electricity, where there is no provisions for notice to be issued. Next, disconnection for distress or damage of electric plant. Next, Lordship, kindly turn to next page. Disconnection on request.
Yes.
And fifth one is disconnection for incorrect or wrongful declarations. And the last is that if there is a deemed termination, if the consumer intend or not paid any bill for substantial period, the disconnection has been made and he has not taken period for 6 months, then this is deemed. This is the different issue. So there are 5 instances, Lordship will find, that when disconnection can be made: disconnection for non-payment, when notice has to be issued; disconnection for theft or unauthorized use of electricity; disconnection for distress; and disconnection on request; and disconnection for incorrect or wrongful declaration. So 5 instances are there, Lordship. So as per within the framework of the statute, it is clearly specified that there is no provisions if any disconnection has to be made in terms of the order passed by the authority provided in other act, that is other the Environmental Act or the other act, where asserting the non-obstinate clause, where it has been specified we are duty bound to comply with that direction. And the closure order itself, Lordship, take note on that, closure order itself notified the private respondent as well as to the petitioner for making disconnection. So on that basis, no further notice is necessary. And as per the standard of performance.
No, but out of these 5, situations, where is that you read that clause also where a request is being made, it can be disconnected? Only in section 5 of the A Act. That's it.
Yes.
Nowhere in the
Nowhere in the act it has been specified. And your Lordship, kindly see, as per the mechanism of the ombudsman, who is also the statutory authority, he has to see that where there is a violation of the statute, on that basis they can grant compensation. But as per the statutory provision, no whisper is there where we have committed violation. They says there is no bar in giving notice. But the statutory authority cannot do anything beyond the statute. Whatever provided in the statute, whatever direction has to be complied with as per the statute, we are duty bound. Now, Lordship, kindly see. Paragraph 13 for a moment.
paragraph
Paragraph 13.
13 of
The writ petition. Writ petitions. Page 9. I have made a framework on the basis of which, on which ground we have challenged this order. Paragraph 13. Kindly take note on that. Paragraph 13. Page 9. This impugned final order passed by is bad in law. It is a misinterpretation of the statutory provision of law for the following reason. What are the reasons I have stated before, Lordship? First, the petitioner disconnected the electric line on the basis of mandatory direction given by the respondent number 3, which is binding upon the petitioner under section 5 of the Environmental Protection Act and other law relating to pollution control law. This is first. Secondly, under section 56 of the Electricity Act, the Electricity Authority is inter alia bound to give notice prior to disconnection only in case of non-payment of bill. That I have already stated in the writ petition. But in the instant case, there is no non-payment of bill and such prior notice on the part of electricity does not arise at all. In the instant case, disconnection has been made only to execute the order. So execution of the order has taken place. By the pollution code, it is statutory binding duty upon the petitioner being electricity for making disconnection, and subsequently upon suspending the disconnection order by the respondent number 3, the electricity authority from the date of receipt of such notice immediately reconnected the electricity. Next page, Lordship, page 10. Thirdly, since the temporary disconnection has been made and not a permanent disconnection at the point of time, the electricity authority, as per West Bengal electricity regulation 55 4.10 read with regulation 48, it should be read as 4.10, is statutory bound to raise bill as per contractual load during period of disconnection. Lordship knows that as per regulation 55 that I have drawn to your Lordship attention to clause 4.10.
Yes.
Regulation 55 clause 4.10, that is at page 18 of that regulation. Lordship got that? Your Lordship has taken note on the last occasion also, 4.10, where it is where notwithstanding anything contained contrary elsewhere in any other regulation. Here is also notwithstanding, Lordship. Regulation of commission during disconnection period for any whatsoever, but prior to termination of supply or deemed termination of agreement, the consumer is liable to pay meter rent, minimum charge, and fixed charge or demand charge as applicable. We have acted on that. We have raised that bill within the four corners of 4.10 of this regulation, as well as it has been specified is the perimeter provision in regulation 48. 48
48.
Yes. On the last occasion, I have already cited before, Lordship.
Yes.
Lordship has got the 48. On the last occasion, I have already given
48.
clause 4.10.
46 is here. 46.
48, Lordship. 48.
48.
2 page I have already cited. 48 টা মনে হয় নেই, আমি আগের দিন দিয়েছিলাম।
Yes. It's here.
Lordship got that? And deeply obliged.
Yes. Sir. Yes.
4.10, Lordship. It's a perimetry of provisions, Lordship. Lordship got that? 4.10. Notwithstanding anything to the contrary contained anywhere in this regulation cases where no consumption energy has taken place for a reason whatsoever, including disconnection of supply due to fault on the part of the consumer, but excluding the instances of interruption in supply due to failure on the part of the licensee, the fixed charge or demand charge of a consumer, as the case may be, shall be calculated on the basis of contractual demand. So my humble submission is that we have acted within the four corners of the statute. It's not that whimsically we have raised this bill. We have acted within the four corners of the statute. There is no negligence on our part. Now, next, Lordship, kindly see. On the last occasion, I have stated before your Lordship that your Lordship also knows that better than me, that a ordinary person can do anything unless prohibited by law. But a statutory authority is duty bound to act within the framework of the statute. He cannot do anything unless provided in the law. Now here, I have shown to your Lordship there is no specific provision as per the direction of the authority. We have disconnected the line to execute that order. Not that we have disconnected the line as per the four corners of the provision. Now, I am citing one decision 2018 4 WBALR 258, where I have got the occasion to appear, where certain decisions has been laid down by this Honorable High Court, where also in the Electricity Act, the act of the section 127 of the Electricity Act has been challenged, where the authority has acted beyond the statute. And this honorable court was pleased to set aside those orders. Now, may I place this? But this is a very important পেজটা বলেছে পেজ না W 2018 4 WBLR Cal 258. May I place it, Lordship? The petitioner files present writ petitioner assailing the interim order dated such and such passed by the appellate authority WBACDCL Howrah. Dr. Shara, advocate appearing for the petitioner distribution company, submit that the appellate authority has no authority or powers to pass the interim order to that effect, by thereby directing respondent number 2, who is a consumer of the period, to deposit 50% of the final assessment order. In the impugned order, the appellate authority further directed the licensee to restore the supply to the private respondent. Shara further content that as per subsection 2 of section 127 of the Electricity Act, before preferring statutory appeal, the consumer should deposit 50% of the final assessment bill. Unfortunately, this provision has not been complied with by the respondent number 2 before preferring an appeal before the appellate authority. Further vehemently urged that the respondent number 2 initially filed writ petition in such and such before the honor assailing the final assessment, giving leave to the respondent to approach before the appellate authority as per section 127 of the said act in accordance with law. If so, unfortunately, the statutory appeal was preferred without depositing 50% of the final assessment order, which is the mandatory provision of section 127 of the act. Further submit that the appellate authority has not been empowered by the act to allow the respondent to deposit 50% order to regularize the appeal. Dr. Further emphasis that being a statutory body, the appellate authority, Lordship, kindly take note on that. This is the main thing which I am showing to your Lordship. The statutory body, emphasis that statutory body, the appellate cannot act beyond the scope of the act. Unfortunately, in the present case, in the hand, the order has been passed by appellate, thereby traveling beyond the jurisdiction. In support of this contention, he relies on the constitutional bench decision of AR 1969, Supreme Court 634. I have brought that judgment, paragraph 4, where the famous Taylor versus Taylor case. In that decision, the Supreme Court held that a statutory body should act within the scope of its jurisdiction or authority, but cannot act beyond the scope of the jurisdiction. He further emphasized that an ordinary prudent man can act unless he is prohibited by law, but a statutory body cannot act unless it is provided by law. Also relies on one apex court decision reported in such and such 2001 SCC, which I will cite before your Lordship, where it is held that if a statutory body, Lordship, kindly take note on that, if statutory body uses its power in a manner not provided for in the statute or passes an order without application of mind. I am asserting on that point, Lordship. First thing, that the ombudsman has passed this order without application of mind, without going to the act which has been made by the authority within the within the four corners of the statute. Nothing has been specified that the notice has to be issued as per the direction given by the environmental authority, and there is a specific provision, but we have violated that provision. Nothing like that. He says there is no bar, so if you have not issued the notice, it is illegal. So this is the, I am not going through that it has been finally set aside, Lordship.
Yes.
So my humble submission before your Lordship, that when statute provides to act within the framework of the statute, the statutory authority has acted within the four corners of the statute. And it has been empowered to the ombudsman authority, who is also a quasi-judicial body, who is also a statutory authority, to act within the frameworks of the statute. He cannot act under section 151 of the Civil Procedure Code. He cannot have got the empowerment under article 226. He has got the power within the framework of the statute. If the standard of performance is violated, only then he can grant compensation. That has not been done. I will not take much time before Lordship. Another thing, Lordship, I draw your Lordship kind attention. But that the decision which I have cited on the last occasion before your Lordship, 2007 1 SCC 437. Lordship got that?
Yes.
I am relying upon paragraph 19 to 21. When the judicial review can be made, Lordship. It is well settled proposition of law. Lordship knows when there is an illegality, irrationality, procedural impropriety, and if the decision has been made by non-application of man without considering the provision of the statute, then judicial review can be made under Article 226 of the Constitution. Now, may I place it? This is a case, paragraph 9, this is a case, albeit on the different issue, but the point of law has been laid down. When an employee by reason of an alleged misconduct is sought to be deprived of his livelihood, the procedure laid down on the sub-rule are required to be strictly followed. It is now well settled that a judicial review would lie even if there is an error of law apparent on the face of the record. Now, Lordship, kindly see this one. This is the most important for which I am citing before Lordship. If the statutory authority uses its power in a manner not provided for in the statute or passes an order without application of mine, judicial review would be maintained. Now, paragraph 20, where Supreme Court judgment has been relied upon, where it has been specified, the authority therefore posed also a wrong question, what therefore was necessary for such and such ingredient contained in such and such was fulfilled and whether requirement of the appendant that was satisfied. If the same had not been, the requirement of law must be held to have not been satisfied. Now, next there is from if there had been no proper application of mind as regard of the requirement of the law, the state authority must be held to have misdirected themselves in law which would vitiate the impugned judgment. My respectful submission before your Lordship that the statutory provision has not been complied with and he has made this order by non-application of mine. And this is a fit case where under Article 226 one can invoke this writ jurisdiction. Paragraph 20. And next to your Lordship, the survival judgment, error of fact can also be the subject matter. Next page, Lordship. Error of fact can also be the subject matter of judicial review. Reference in the may also made in interest such and such case. Judicial review has been specified. Now, here, the decision I have, two decisions I have cited before your Lordship. First decision is that so far the judicial review is concerned under Article 226, if there is any non-application of mine, if the statutory body has not acted within the framework of the statute,
Yes.
then judicial review is permissible. Another judgment I cited relating to the non-obstinate clause, relating to the notwithstanding, it override this act and also the other act also. And apart from that, in the regulation, it has been provided that in the clause 4.10 as well as in the regulation 55 as well as regulation 48 clause 4.10, where it has been specified notwithstanding clause for granting, even if there is a disconnection, we can raise the average bill. So my humble submission before your Lordship that as per this order, I pray before your Lordship, this order should be set aside and upheld the order passed by the concerned GR. This is my respectful submission before Lordship.
Lord, you will also kindly straightway come to the order, including order, my lord, page 45.
You are appearing for respond number?
Respond number 1 and 2, basically, my lord, 1 is the ombudsman, my lord, ombudsman is represented by the WBS. Your lordship, page 45, third paragraph. Hence, it is held that since this is a case of wrongful disconnection, page 45 of the writ petition.
Page 45 of the writ petition.
So let's say
This is the
page
order.
4 of the impugned order. Hey, third
Para
paragraph.
13,
Third paragraph.
third paragraph, yes.
Just before para 13. Hence, it is held that since this is a case of wrongful disconnection, there cannot be any demand fixed charges during the period of wrongful disconnection in terms of such and such. But the whole case, my lord, on the basis of whether it is a wrongful disconnection or it's a correct disconnection. Now, your lordship kindly come to page 31 of the writ petition. The submission of the licensee before the ombudsman. Kindly see the second paragraph. The reasons for disconnection. As per section 56, a non-payment of OSD, my lord, that is outstanding dues.
Where are you reading? Sorry,
Page 31, my lord.
page 31. Page 31, yes.
It says, my lord, the submission of the WBSCDCL before the ombudsman. Which is second paragraph, my lord. The reasons for disconnection. As per section 56, a non-payment of OSD, my lord, that is outstanding dues. Bill amount, either reasons for the disconnection as per regulation 55 WBSC are as follows. Well, kindly see the clauses. 4.1, 4.2, 4.3, 4.4, 4.5, and 4.6. My lord, the WBC SCDCL have the knowledge about regulation 4.3 of regulation 55. Now, your lordship kindly come to regulation.
But they would be covered under 4.4.
No, 4.3. My lord, kindly see. Kindly come to 4.
Their argument is 4.3 or 4.4?
My argument is there is no notice is required to be given under these regulations.
4.4 is disconnection on request.
Disconnection on request.
No.
So this is on
That
request.
the request has to be made by the consumer, lordship.
It's by the consumer.
Consumer. This is not the request made on the basis of the consumer has made this request. This has made by the authority.
The case of the WBSCDCL is that the pollution control board directed them to disconnect the supply.
Correct.
Because of
So
that,
they are saying basically their case is that they are covered under section 5 of the Environmental Act, and none of the provisions of the regulation or the Act, Electricity Act covers them. And they are using the non-obstinate clause, which is section 5, it says notwithstanding anything in any other law. So that empowers them to disconnect it.
my lord, this situation, my lord, it covers also, my lord, the regulation. Covers by the regulation. My lord, kindly come to, my lord, regulation 55. It starts from page 68 in the bunch. And straight away, my lord, come to page 83 of the regulation bunch.
Page 80?
83 of the bunch, my lord. 4.3.
Yes.
The 4.3, my lord, says, my lord, disconnection for distress or damage to the electrical plants, electrical lines, or meter, or for prevention of loss of human life and property. My lord, kindly mark this. Page 83.
83, yes.
83, my lord, 4.3. The disconnection for distress or damage to the electrical plants, electrical lines, or meter, or for prevention of loss of human life and property. Well, because of this, they can disconnect. Now, kindly come to page clause 4.3.4, that is at page 84. In emergency circumstances, or the PCB, my lord, issued the notice and directed them to disconnect the supply. But I take it as an emergent situation because of the human life is, my lord, for my lord, pollution, my lord, human life is also in danger. In emergent circumstances where any action of a consumer in using the energy supplies may, in the opinion of an officer of the licensee, not below the rank of a sub-assistant engineer, cause injury to any person or cause loss of human life and or property, the licensee may disconnect supply to the consumer within the notice period as stated in regulation 4.3.2. Or, now my lord, can see, or even without any notice. Either notice or without notice. They can disconnect without notice. In such a case, the officer of the licensee who is taking the decision to disconnect must submit a report within 24 hours of disconnection to his immediate superior officer, who shall recheck the facts on the basis of which the decision to disconnect the supply on the ground of emergent circumstances as laid down was taken, and now inform the consumer in writing. Inform the consumer in writing the reasons leading to such disconnection within a period of 48 hours from the time of such disconnection.
But sir, this is not the argument advanced by him.
That is the point. They are violating this regulation.
No, they are not saying this. They're not arguing this also. They are saying that the regulation doesn't cover them.
This is covered, but it's an emergent situation. Pollution Control Board directed.
Emergent situation is not for them to assess. They are not assessing the emergent
I
situation.
am not saying that they have to assess. I am saying
They
that.
are not assessing it. That's what I'm
I'm saying
saying.
that the
that
Pollution Control Board directed them to disconnect the electricity supply. They have the right to disconnect the supply under 4.3.4. But after disconnection, they have to give the notice to the consumer saying the reasons for why they disconnect the line. What is that notice?
That's the argument which they are saying, that they are not covered in any of the regulations before they are disconnecting it. They are disconnecting it only based on the direction given by PCB under section 5. So all these regulations are not attracted in a situation like this, where they are acting on the advice and advice of the PCB. That's
Sir,
their argument.
As a consumer, my lord,
And substance
as
of
a
the
consumer, my
argument
lord, I must know the why the electricity company, my lord, disconnect my line.
you have already been served with the notice. The day you are being served with the notice, that can be a deemed notice even on behalf of the electricity company, that this action is being taken. When PCB serves you with a notice of closure, they are also pointing it out in that notice that your electricity connection will be disconnected.
That is, my lord, taken
That
care
is
of.
also a notice that
My
can be
lord, that
deemed
is,
to
my
be a
lord, taken
notice.
care of by the in the 4.3.4.
This is not attracted. This entire scenario is not attracted. This is not their ground at all. They are not alleging this ground. This is your thinking. This is not what they are arguing also. They themselves admit to the fact that none of the 5 situations which have been imagined, emphasized, or thought of in your regulation is attracted in their case.
In my submission, my lord, this is attracted. And for that reason, my lord, this is wrongful disconnection.
What else?
Now, this is my submission.
File your reply.
My lord, I am for the private respondent, the aggrieved consumer.
Yes, tell.
My lord, my lord, adopting the submission made by the ombudsman, my lord, I will only add, the ombudsman has only read into the compliance of principal natural justice while dealing with this issue. My lord, on this issue, my lord, I will refer to a judgment of 3 judges bench of Supreme Court, my lord. 1981, 1 SCC, page 664. My lord, what has been canvassed before your lordship by the petitioner is that the neither in the act nor the regulation made therein prescribe or cast a duty upon the department to serve a prior notice before the disconnection. My lord, this situation has been dealt with, my lord, unless and until the statute expressly bars or by way of necessary implication prohibits compliance of principal natural justice, the authority has to comply with such requirement. My lord, in my respectful submission, under section 5, the Pollution Control Board, under section 5 of the Environment Protection Act, my lord, the Pollution Control Board, in order to prevent any loss or damage to human life, property, or to damage to the environment, can certainly give any direction under section 5. My lord, following this, the electricity department has a duty to act, certainly. But my lord, neither in section 5 of the Environment Protection Act 1986 or section 33A of the Water Act or section 31A of the Air Act, my lord, by express prohibition or by necessary implication, oust the application of principle of natural justice. My lord, I will refer to paragraph 31 and 34.
Read.
My lord, paragraph 31 to 34, page is at, my lord, 684.
Read it.
The rules of natural justice can operate.
Just a minute.
Sorry, man.
Yes.
The rules of natural justice can operate on.
Are you reading?
But paragraph 31 to 34.
Yes.
The rules of natural justice can operate only in areas not covered by any law validly made. They can supplement the law but cannot supplant the law. If a statutory provision either specifically or by inevitable implication exclude the application of the rules of natural justice, then the court cannot ignore the mandate of the legislature. Whether or not the application of the principle of natural justice in a given case has been excluded wholly or in part in the exercise of statutory power depends upon the language and basic scheme of the provision conferring the power. the nature of the power, the purpose for which it is conferred, and the effect of the exercise of that power. The maxim ad alteram partem has many facets. Two of them are A, notice of the case to be made, B, opportunity to explain. This rule is universally respected and duty to afford a fair hearing. In Lord Loreburn's oft-quoted language is a duty lying upon everyone who decides something in the exercise of legal power. The rule cannot be sacrificed at the altar of administrative convenience or celerity. For convenience and justice, as Lord Atkin felicitously put it, are often not on speaking terms. The next general aspect to be considered is, are there any exceptions to the application of principle of natural justice, particularly odi alteram partem rule? We have already noticed that the statute conferring the power can, by express language, exclude its application. Such cases do not present any difficulty. However, difficulties arise when the statute conferring the power does not expressly exclude this rule, but its exclusion is sought by implication due to the presence of certain factors, such as urgency, where the obligation to give notice and opportunity to be heard would obstruct the taking of prompt action of a preventive or remedial nature. It is proposed to dilate a little on this aspect because in the instant case before us, exclusion of this rule of fair hearing is sought by implication from the use of the word immediate in section 18AA1. Odi alteram partem rule may be disregarded in an emergent situation where immediate action brooks no delay to prevent some imminent danger or injury or hazard to paramount public interest. Thus, section 133 of the Code of Criminal Procedure empowers the such a skipping over. Similarly, action on grounds of public safety, public health may justify disregard of the rule of prior hearing. Be that as it may, the fact remains that there is no consensus of judicial opinion whether mere urgency of a decision is a practical consideration of which would uniformly justify non-observance of even an abridged form of the principle of natural justice. In such and such, Lord Upjohn observed that while urgency may rightly limit such opportunity timelessly, but perhaps severely, there can never be a denial of that opportunity if the principles of natural justice are applicable. Well, let me then kindly come to paragraph 94, which is at page 709. Yes. The further question to be considered is, what is the effect of the non-observation of this fundamental principle of fair play? Does this non-observance of odi alteram partem rule, which in the quest of justice under the rule of law has been considered universally and most spontaneously acceptable principle, render an administrative decision having civil consequences void or voidable? In England, the outfall from the watershed decision, Rich versus Baldwin, brought with it a rash of conflicting opinion on this point. The majority of the House of Lords in Rich versus Baldwin held that the non-observance of this principle had rendered the dismissal of the Chief Constable void. The rationale of the majority view is that where there is a duty to act fairly, just like the duty to act reasonably, it has to be enforced as an implied statutory requirement, so that the failure to observe it means that the administrative act or decision was outside the statutory power, unjustified by law, and therefore ultra-virus and void. In India, this court has consistently taken the view that a quasi-judicial or administrative decision rendered in violation of the odi alteram partem rule, wherever it can be read as an implied requirement of the law, is null and void. In the facts and circumstances of the instant case, there has been a non-compliance of such implied requirement of the odi alteram partem rule of natural justice at the pre-decisional stage. The impugned order therefore could be struck down as invalid on that score alone. But we refrain from doing so. My lord, that was not done ultimately. And well, this is my respectful submission, my lord, that neither the Environment Protection Act or the Air Act or Water Act expressly ousts the applicability of principles of natural justice. My lord, I am in respectful agreement with my learned senior friend that they has a duty to act, but such duty comes with, my lord, corresponding, I have a right to get an opportunity of or a prior notice. My lord, I have the notice, my lord, I have the closure notice received on 11th April. I have received that. But my lord, against that, under section 16 of the National Green Tribunal Act, I have a remedy to prefer an appeal before the National Green Tribunal within a period of 30 days. My lord, such notice does not says that it has to be disconnected within 48 hours. But it was done. My lord, after the disconnection, I would not prefer any appeal, my lord, before the National Inquiry Tribunal against such order, because that would be, my lord, the waste of judicial time. So, my lord, thereafter I approached the Pollution Control Board, contest the matter, and after, my lord, thereafter the closure order was revoked and electricity connection was restored. But, my lord, when the compliance of natural justice has been violated, my lord, I have just pointed out the paragraph 94, which says that the mandatory compliance renders the action null and void. My lord, the time and again, the ombudsman has asked from the authority where you have to show the whether it is barred to give any notice. My lord, they have failed to show. They are only harping on the issue that under the regulation they are not duty bound to do so. My lord, with deepest humility, may I submit, my lord, the law of the land says that unless it is expressly or by impliedly it is excluded, they have to comply the principle of natural justice. They have to give notice, prior notice to me before effecting the disconnection. My lord, the regulation 55, which my learned friend, the appearing for the ombudsman, has referred, it also conceives of an emergency situation, but certainly the emergency situation does not necessarily includes that a order from the competent authority by the Pollution Control Board. But, my lord, your lordship knows, my lord, this environment, while the pollution has certainly an adverse impact over the life as well as property, including the agriculture or, my lord, the water, my lord. So, therefore, this situation will also come as an emergency situation. Even on that emergency situation, my lord, they can disconnect without notice, but some safeguards have been provided. Even then, they have also not followed that. They could have done it within 24 hours. My lord, in the writ petition, they have not annexed any such report that the authority which has effected the disconnection submitted a report before his superior that by way of this emergent order situation, as per the direction of the I have disconnected, and such order was communicated to me within the 48 hours as per the clause 4.3.6 of the regulation 55.
You are asking for a stay of the order.
Stay of the order.
Take down. Learned counsel of the petitioner has challenged the order passed by the ombudsman dated 10/9/2024. Full stop. By the said order, the electricity ombudsman has held that the petitioner is liable to pay compensation for wrongful disconnection from 13/4/2023 to 14/6/2023. It is further held that they shall waive the demand/charges as claimed during the period of wrongful disconnection from 13/4/2023 to 14/6/2023. That's right, Mr. Saad. These are the only two observations.
Lordship.
Yes.
May I take your lordship's kind leave?
Yes, yes. Learned counsel for the petitioner states that the electricity connection was disconnected on the direction of where is that
Page 17, Lordship.
page?
17, 17. Lordship, got that? 17.
learned counsel for the petitioner states that the electricity connection was disconnected on the request of Chief Engineer, Operation and Execution Cell, West Bengal Pollution Control Board. It is contended by the learned counsel for the petitioner that a notice was served upon the respondent, respondent number
Respondent number 4,
on 13/4/2023, whereby they were asked to close down their business activities, as well as a direction was issued that the electricity connection of the unit shall be disconnected forthwith. Learned counsel for the petitioner has relied upon section 5 of the Environmental Protection Act 1986, which reads as under. It is contended by the council that under section 5 of the Environmental Protection Act, a direction has been issued by the Pollution Control Board, wherein they had been asked to disconnect the electricity connection. In furtherance of his argument, he states that where's that judgment?
AIR 2005.
In furtherance of his
AIR
argument,
2005 Supreme Court
he
514.
relies on
Paragraph 32.
the judgment of Shivraj B. Patil. The judgment of, sorry, which is this?
AIR 2005 Supreme Court 514.
Supreme Court
Para
514.
32. At page
Wherein
5.
It has been held that the expression, notwithstanding anything contained in the act or in some particular provision in the act or in some particular act or in any other law for the time being in force or in any contract is more often than not appended to a section in the beginning with a view to give the enacting part of the section in case of conflicting and overriding effect over the provisions of the act or the contract mentioned in the non-obstinate clause. It is equivalent to say that in spite of the provisions of the act or any other act mentioned in the non-obstinate clause or any contract or document mentioned, the enactment following it will have its full operation, and the provisions embraced in the non-obstinate clause would not be an impediment for an operation of the enactment. Full stop. In view of the same, learned counsel for the petitioner states that though there was no express provision under the Electricity Act or the rule wherein any violation has been made by the respondent for disconnection in this particular situation, but due to the direction issued by the Pollution Control Board and due to the direction issued by the Pollution Control Board under section 5 of the Environmental Protection Act 1986, they were duty bound to carry out the directions. Full stop.
Your Lordship, one indulgence. Your Lordship, can I just one thing? Your Lordship, kindly stop the recovery amount that they are paying for.
Sorry?
Your Lordship, kindly stop the recovery amount that they are paying for, as was said by.
Kindly, I didn't follow that. What are you saying?
Your Lordship, Status, Your Lordship, the status quo order, I mean, they were paying for the recovery amount that can be stopped or
না আমি
something.
রিকভারি এমন চাইনি তো কিছু, আমি স্টে অফ দ্য অর্ডার চাইছি। দেখো কি বলছি,
Sorry, Your Lordship.
ইন্টারাপ্ট করছো কেন অর্ডার যখন দিচ্ছি?
क्या लिखा है क्या लिखा है
করে নাও। কোথায় রিকভারি এমন চাইছি? হ্যাঁ।
full stop. Learned counsel for the petitioner further relies upon Rule 55,
Regulation 55,
Regulation-
Regulation 55, clause 4.10.
Regulation 55, clause 4.10.
Your Lordship can see the paragraph 13 where it has been laid down. Paragraph 13.
Regulation 55, clause 4.10, read with Regulation 48, clause 4.18.
It should be 4.10 of Regulation 48, Lordship, and also clause 10, clause 4.10 of Regulation 55.
55.
Lordship.
So 48 also 4.10.
48 also, not comma, 48. That's why I have cited before your Lordship. Regulation
55
48,
read with-
clause 4.10,
And 55, what is the clause?
4.10.
All right, not 4.18, 4.10 both. Clause 50, Regulation 55, clause 4.10, read with Regulation 48, clause 4.10.
I'm deeply obliged.
To buttress his argument that they were statutory bound to raise bills as per the contractual load during the period of disconnection. Full stop. These are the only two arguments.
Lordship. One pertaining to notice and one pertaining to this bill.
Learned counsel for the petitioner further states that they had not issued any statutory notice to the private respondent number 4 before disconnecting, since they were acting under the directions of the Pollution Control Board,
Executing the order. Executing the order.
executing the order of the Pollution Control Board, which had already given a notice to the private respondent number 4 on 13/4/2023, wherein it is also reflected that their electricity was also to be disconnected. Full stop. Learned counsel for the petitioner further submits that in this particular situation, WBSEDCL was not in a position to verify whether the order passed by PCB, wherein they had given the direction for the disconnection of the electricity, was correct. Full stop. Learned counsel for the respondent relies on respondent number 2, contends that under no circumstance the disconnection should have taken place without issuance of proper notice. They allege that it's a violation of principle of which is the section which you were quoting?
4.3.4, my lord, page 84 of the application. The violation of regulation 4.3.4 of regulation
Violation of natural justice.
55.
Full stop. He relies on regulation 55, subclause 4.3, wherein he states that even in a scenario where the disconnection is to prevent loss of human life and property, in that emergent situation also, a notice shall be issued
After disconnection, that is 4.3.
issued to the respondent. Full stop. To further his contention, he relies on clause 4.3.4, wherein even after disconnection, an inquiry, what is it, 24 hours, a report, even after disconnection,
48 hours. And a notice to be given to the
Uh,
consumer after 40. within
a
48
notice has to be given to the consumer after 48 hours,
within 48
within
hours.
48 hours of the disconnection, within 48 hours of the disconnection. Learned counsel for the private respond number 4 also contends that the principles of natural justice were not followed and they were not served with any notice prior to disconnection. Full stop. This court is of the view that the petitioner had carried out the disconnection in view of the notice issued by the West Bengal Pollution Control Board dated 13/4/2023. Full stop. A mere perusal of the notice shows that there was a direction to the electricity company for disconnection. Full stop. The contention of the learned counsel for the petitioner that they had merely executed the directions of the Pollution Control Board seems to be plausible. Full stop. It is also the notice of the Pollution Control Board was served upon the private respondent and thereafter served upon the private respondent. When was the disconnection taken place?
But disconnection taken place on 13/4/2023.
Same day.
No, not same day. After receiving of the notice, 13/4/2020.
Where do you get that?
I have stated in paragraph that I have already stated. Paragraph 5, Lordship. Page 5, Lordship. Paragraph 4 and 5. And subsequently reconnected after receiving on the notice. Now you will find in paragraph 4, 5, and 6 at page 5.
नहीं, the note वो line काटते हैं. It is further, this court further notes that the electricity connection was restored. Where is that letter? That
Next page, Lordship. I have stated in paragraph 6 and annexure B. Sorry, P2.
P2
Page 19, Lordship. The day when we have received, the day we have very day we have already.
The electricity connection was restored on 13/6/2024 on the direction of the West Bengal Pollution Control Board.
On 16/6/2023,
on 16/6/2023.
paragraph 6 I've stated.
Thus, the contention of the petitioner that they had acted on the instruction of the Pollution Control Board at the time of disconnection as well as at the time of restoration of the electricity connection. Full stop. Restored on 16/6. 16/6. 16/6. Learned counsel for the respondent seeks 4 weeks time to file his affidavit in opposition, reply to the same, if any, within 2 weeks thereafter. In the meanwhile, the operation of the impugn order dated so and so shall remain stayed for a period of 2 months.
Yes,
For a period of 2 months. Date declared 2 months.
my impugned order were passed. Your lordship, kindly see the date. The pass by the
14/9.
yes.
The 10/9.
10/9/2024.
10/9/2024 shall remain stayed for a period of 2 months, which will be date declared. Or until any
Until further. I'm deeply obliged, lordship.
ये ना ये बड़ा अच्छा है, इसको रख लेना, जजमेंट्स फाइल में डाल दो, ठीक है, नहीं देखे गया है, हाँ जजमेंट रखा डालो, जजमेंट फाइल में डाल दो, ये भी रख लो, इसको हटा दो, ये सारा रख लो, ये रख लो, ठीक है, इसको हटा, वो फाइल में डाल, नेक्स्ट
Between 55 and 58, just provide us that may have indulged to take 20 minutes part over. My junior will be here.
What kind of submission is that?
Only short parts over may take not.
You are such a seasoned lawyer. I mean, I'm amazed, Mr. Nayak, to see somebody like you mentioning in the middle of arguments. It is so discomforting. It is so sad. Somebody like you, Mr. Nayak, if it is a young boy at the bar, I can still understand. But somebody like you with this kind of experience during the ongoing court proceeding, mentioning in the middle of the court proceeding is so unfortunate. So unfortunate. It just shows you have no respect for the court. It really breaks my heart to see somebody like you do this.
I'm
Very sad. Yes.
And I appear on behalf of the CSC in this matter.
Lordship, I beg to appear on behalf of the petitioner. The petitioner applied for the new electricity connection in the year 2011.
One item है? This 43, right? Yes.
Petitioner, this is the affidavit of service, Lordship. I have served the respondent number 4 that has not been delivered. The Deputy Chief Engineer.
Who's respondent number 4?
Well, I am representing CSC, man.
You're there.
The
Yes.
petitioner applied for new electricity connection in the year 2011.
and the MSD bill is at page number 21. I deposited the quotation, the amount, but till date, no electricity connection has been provided. After filing of this writ petition, Your Lordship, I received a letter, though the date is mentioned as letter dated 13/11/2022, but I received, it was post on 15th January 2025, wherein it is stated that despite repeated efforts, we have not been able to complete the new connection at your premises due to reasons beyond our control. It appears that at present, there is no requirement of the new connection you had applied for. In view of the same, we would request you to kindly contact the undersigned with the original copy of the MASD bill payment receipt and apply for refund of your paid bill amount within 15 days. And till that I'm seeking the electricity connection. I don't want refund.
Probably,
Yes.
probably my learned friend is not instructed properly because I could not find any of the documents which are relevant has been annexed with the writ petition. Now, may I hand over a copy of the order dated 16/10/2012 first?
Same property?
My lord,
Same property?
same property, same person. My lord, will kindly see, may I have your lordship's kind leave to read the order, my lord? Although the petitioner seeks new electrical connection domestic to their premises for such purpose, electrical lines will have to be drawn over the land of the private respondent number 7 to 10. A written objection has been filed by the private respondent on 11/11/2011 with the respondent number 3, and the same has also been received by the private respondent. The title suit such and such has also been filed and a show cause was issued to the respondent number 3. The private respondent have contended that there is an alternative route over which lines can be drawn to effect connection to the premises of the petitioners. To ascertain the veracity of the said statement, respondent number 3 is directed to depute an inspection team on 20th October 2012 at 12 noon, when the representative of the private respondent number 7 to 10 will also be present and will definitely identify the alternate route over which lines may be drawn. In the event the said alternative route does not encroach over the lands of any private individual, but involves Panchayat road or government land, steps will be taken by the respondent number 3 to effect electricity to the petitioner's premises upon compliance of all formalities within 3 weeks by the petitioner. In the event the alternative route is over the land of a private property, no step need to be taken without his consent. An objection has been filed by the private respondent, the same be also disposed of by the respondent number 3, that is the district engineer, within 2 weeks from the date of receipt of this order, after giving an opportunity of hearing to all parties and by passing a reasoned order. This reasoned order was passed on 9th of November 2012. May I, with your lordship's kind leave, my lord, hand over a copy of the reasoned order. And in the said reasoned order,
Why you have not put all this?
Yes,
My
Lordship.
lord, why you have not put all this?
I have to take instruction from the advocate, advocate on record, because only whatever I have instructions I have placed before your lordship. Let him appear before.
This is absolute.
Yes, lordship.
suppression of-
Yes, lordship. Yes, lordship. Let him
Complete
come.
suppression of.
Yes, lordship. Let him come appear before your lordship. I'm intimating him.
my lord, what
Because he has been, he has engaged.
what instruction which I have got, my lord,
Yes,
in the said reasoned order, my lord, the district engineer has found that the line which has there is no alternative line, and there is already, my lord, a existing line is there in respect of a private passage. So the district engineer has stated that to make a T-joint over a panchayat property and to provide him electricity. That was in 2012. After that, around 7 to 8 times, the CSC has tried to put on that T-joint. We could not, because of the objections, my lord, raised by the respondent number 7 to 10. My lord, on 9th of January 2025, we have inspected, my lord, in respect of the, tried to inspect in respect of the said existing underground line. My lord, what we have found that the service cable laid under the disputed passage was never energized. My lord, what we have to do now, my lord, firstly, we have to inspect with police protection to see whether we can energize the line which is already there and to put up a T-joint so that we can provide. If my lord so directs us, we can inspect and come up. But otherwise, my lord, he has to put in before this court these documents because these documents are not
The
there.
advocate on record first come and explain why he has not put all these things before the court.
Cannot pass this order, my lord, because my lord, there is a suppression, my lord. These things have not been spelled out, my lord. I have also got the other petition, my lord. They have kindly seized, my lord, para 12 of their district petition, my lord. Kindly see, my lord, what their submission, my lord, before this court. Para 12, my lord, they say, my lord, that the petitioner humbly submit that no other application has been filed by the petitioner on the said cause of action before this honorable court, and no fact has been suppressed before by this petitioner, my lord. Now, my lord, a filing of writ petition which was filed,
Refer
my
him to
lord,
the bar council.
Yes, Lord. Kindly adjourn this matter.
and an order passed, my lord, that was also not challenged in appeal, my lord. My lord,
Kindly take up this matter on Monday.
it's a material fact, my lord, that has to be brought before your lordship.
ছেড়ে বার কাউন্সিল করে দেবে তাহলে ডিসমিস করে দিই না বাচ্চা ছেলে বার কাউন্সিল করে দিলে হবে না
I am also not pressing for bar council, my lord.
হ্যাঁ
That I leave you,
let him
my lord. Kindly, my lord,
Absolute suppression.
হ্যাঁ there is my lord
gross
but
material suppression of fact.
No, Lordship, I will not submit. Kindly let him appear.
Ask
Because
him
he is
to withdraw
engaging
this petition and pursue with them.
Yes, Lordship, because he is given me instructions. I have been engaged as a counsel, but he is not he will not supply the proper instruction. Let him come and explain.
So file करने का. When do you want it?
Monday, Lordship.
may I take back the order of which
Give back the order.
এইটা থাক এটা আমার কাছে কপি হ্যাঁ অর্ডার তো দেবে
Monday. Tuesday. When do you want? Acha. Learned counsel for the respondent has pointed out that there was an earlier round of litigation and the petitioner had filed a writ petition on the self cause of action. Full stop. Mr.
Surajit Basu.
Surajit Basu
এই অর্ডারটা দেখে নাও
appears and states that the advocate on record has not given him clear instructions and he is not aware of any such writ petition being filed. He seeks time to take instruction from the advocate on record as well as the client. Let this matter be listed on Tuesday.
Tuesday, Lordship.
I'm good.
I tender apology, Lordship. I was engaged as a counsel. I was.
But you should know, even if you're engaged as a counsel, you should
Lordship,
know.
I have asked everything. Tell me the facts of the case.
Where is he?
He has not come to court. I have some difficulty. Kindly appear in this
তুমি
matter.
এটাকে withdraw করে নাও পরে you should withdraw কারণ বেকার
Next.
Your Lordship, in item number 55, I'm appearing on behalf of the petitioner being led by Mr. Vishwajit Bose. The matter pertains with forceful installation of 2 electricity poles on my property, Your Lordship. The respondent authority had installed the electricity poles with the influence of the private respondent, who is a certain influential person of that locality. I have several times I have issued several objections, including the notice also, but they haven't paid any heed to my grievance. My Lordship, kindly come at the page number 26. That is the photographs.
Page number 26.
Page number 26, Your Lordship.
Yes, what is there?
This is, Your Lordship, I'm tendering unconditional apology. Means there are two plots, Your Lordship, where they have installed two electricity poles. And this is absolutely violation of the statute, Your Lordship. Let me show the statute to Your Lordship.
It is your land.
It is my land, Your Lordship. The deed is also annexed at the page number 21, Your Lordship.
Yes.
The deed.
My lord, the case is this, my lord, since 2005 to 2022, from that supply, my lord, 3 other persons are getting electricity, those who are not party to this. Now at this juncture, this man wants the 3 poles existing on his property. According to him, he is claiming it is my property to be shifted. Now, my lord, anybody, any consumer can make such application. There is no bar. But point is, this law says if that be so, in that event, he'll have to provide accommodable, my lord, area where it could be shifted. And
No, but why
alternative-
should he give
Right.
you the alternate plot?
Because it is already existing, because others are enjoying electricity, we have drawn line.
It's all right. The others who are enjoying the electricity, they have to give a
Right.
place, not him.
No, he
Lordship, they-
accepted, my lord, in 2005, and we are in 2025. Before 20 years, then all supplies are
Last
kind.
20
Firstly, Your Lordship,
Yes,
they
that is
firstly, Your
clear.
Lordship, they then took our permission and they have the certain instruction to
Since
take
when
the
is
way
this-
live certificate, Your
Since when is
Lordship.
the pole there?
The pole?
Since when is the pole in that property?
The pole was the pole was installed, Your Lordship, as per my instruction before 2 years ago. As per my instruction.
But my specific instruction, since 2005, prior to that, it was there.
And
But
he
from
made certain
2005,
applications, Your Lordship.
3 new connections have been given.
And Your Lordship, kindly consider.
Therefore,
Yes.
Lordship, it is possible. Let them.
There's the erection of pillars in my land. That's it.
Since 2005.
My lord, we have made several communications, several requests. The latest representation I've annexed few of them. My lord, let
But
them
decide
show.
his, decide his
on the-
representation.
Lordship.
Decide his representation. Learned counsel of
Yes.
the petitioner states that
My lord, only
WBCDL has erected poles on his property. It is his contention that he has made several representations for removal of the said poles from his property, but the same has fallen on the deaf ears of WBSEDL, the respondent company, WBCD. Full stop. Learned counsel for the respondent authority, WBSEDL, states that they will decide the representation of the petitioner within 4 weeks, 6 weeks,
Within 1 month
within 4 weeks
after communication, Lordship.
from the date of passing of this order. Full stop. After affording an opportunity of hearing to all the necessary parties. Full stop. Learned counsel for the petitioner states that he will be satisfied if his representation is addressed. Full stop. The counsel for the petitioner states that he is satisfied with the statement made by the learned counsel for the respondent. At this stage, nothing survives in the presented petition. The same is disposed of in terms of the above direction.
only in this. My lord, is if they can show, because they have taken prior consent.
Let
I know, my lord, I know.
Let them decide it.
Representation only in 2024.
That's what
What's that?
17/9/2024.
I'm grateful, Your Worship.
Well, kindly make it specific that the concerned station manager will decide. Otherwise, WBCTCL, then they may take time.
Representation, he has given it to the
Yes,
station
yes,
manager
yes.
only. Representation dated 17/9/2024.
That is there.
Will be decided by the concerned authority.
I'm obliged to Lordship. Disposed of.
I'm grateful, man.
No issue.
From the date of
commentary এটা চলছে
from the date of uploading of from the date of server copy of communication.
Item number 58.
ঠিক আছে what I appeal
From the date of communication of this order, sir, you communicate the order. Once you get the server copy, you communicate.
I'm grateful, man. Well, I'm for the petition in action number 9, my lord.
Billing dispute,
Yes, my lord,
go before the RGRO.
my two representation has not yet been considered by the respondent.
Go before the RGRO, sir. Billing dispute, go before the RGRO.
I may oblige you lordship.
The petition is aggrieved by the exorbitant electricity bill raised by the respondent. Full stop. Learned counsel for the respondent submits that the grievance raised by the petitioner can be addressed by the regional grievance redressal officer under clause 3.5.1 of the West Bengal Electricity Commission notification dated 7th August 2013. If the petitioner is aggrieved by the order of the RGRO, he can prefer an appeal before the ombudsman. Full stop. In view of the submission made by the learned counsel of the respondent authority, the petitioner seeks to withdraw the present writ petition with liberty to approach the regional grievance redressal officer in accordance with law. The said prayer is allowed. The present writ petition is disposed of in the above terms.
Extremely grateful lordship but I may be excused lord I apologize lordship
No problem.
grateful
I always accommodate you, Mr. Nayak.
No,
Your
no, I-
junior have been taking date,
I'm
you are not here. Affidavit of service is taken under part.
and it is our additional advantage that my lord knows this subject and also we are taking less trouble lordship. I am grateful
61.
West
Well,
Bengal Central Electricity Commission notification dated 7th August 2013.
My lord, in this matter, I am for the petitioner. Lord, this is my affidavit of service. Lord, my case is this, my lord, that the petitioner, my lord, participated, my lord, in a tender proceeding. My lord,
Who's for the respondent?
respondent is here, he is coming. The tender proceeding. My lord, subsequently, he has completed the work within the stipulated period. My lord, page 12 of my application, my lord, that they have, my lord, executive engineer, my lord, issued a certificate in favor of the petitioner. It was stated in the said, my lord, certificate that this is to certify that home enterprise of such and such has been completed the work as stated below under Bidhannagar Municipal Corporation within stipulated period of time. Lord, thereafter, my lord, he has, my lord, submitted the running bill, that is page 13 of the said my writ application. In page 14, my lord, left-hand side, it was further remarked that the agency has done the work as per specification and direction of EEC. My lord, I made a representation before the authority concerned, my lord, that was the, my lord, still pending before the authority. My lord, yesterday I have submitted before your lordship, my lord, that there are several, my lord, division bench judgment, my lord, I will place before your lordship. My lord, this judgment was passed by Honorable Justice, my lord, Dipankar Dotto, sitting with Honorable Justice Pratik Prakash Banerjee. My lord, the fact of the case was this, my lord, 16, my lord, appeals were preferred by the corporation. My lord, in the said appeal, their contention was this, my lord, in spite of service of notice, my lord, Honorable single judge were pleased to direct the corporation, my lord, to disburse the amount. My lord, against that, they preferred an appeal before the, my lord, Honorable Division bench. Lordship, kindly have a look to page 3. The observation of Honorable, my lord, Division bench, my lord, I have marked. I'm sorry that I have marked. We do not see reason to remind the lead petition for fresh hearing. Interest of justice, in our view, would be sufficiently served if the commissioner of the corporation, appellate number 2, proceed to consider the representation of the respondent number 1 and 2 dated 27 June 2019 in accordance with law and upon granting an opportunity of hearing to the respondents 1 and 2. In the event the commissioner is of the opinion that the respondent number 1 and 2 had executed the work entrusted to them fully and to the satisfaction of the corporation, release of the dues of the respondent number 1 and 2 shall not be unduly delayed. However, if the commissioner is of the view that execution of the works by the respondent number 1 and 2 fall is deficient on any count or there are other reasons for which release of payment claimed by the respondent number 1 and 2 in full or in part would not be permissible in law, a written order shall be passed and communicated to them. Let this exercise be completed as early as possible, but not later than 8 weeks from the date of receipt of a copy of this order. Milord, in this matter, Milord, I also appeared on behalf of the Milord read petitioner and in appeal also Milord respondent. Milord, subsequently, Milord, another judgment was passed by our Honorable Chief Justice sitting with my Lord Mr. Justice Milord Hiranmoy Bhattacharya. So, Milord, this is not my application. This order was passed on 3rd of April 2024. It's Deven. Milord, page 3. Milord, third line. We grant liberty to the appellants to submit a comprehensive representation to the respondent municipal corporation, clearly setting out their claims and including all relevant documents such as your work orders, copies of the bills, completion certificate, etc. And on the receipt of the representation, the respondent municipal corporation shall consider the same and pass a written order on merit and in accordance with law and communicate the same to the appellants within a period of 4 weeks from the date on which the representation is submitted. And we'll let the history, in the last order, here also, Milord, I appeared on behalf of the deed petitioner before the Milord Honorable Single Bench, where Milord Honorable Justice Kaushik Chanda was pleased to direct Milord the corporation to disburse the amount within 2 months, Milord, from the date of communication of this order, along with interest. Milord, against that, Milord, the corporation preferred an appeal before this honorable court. Milord, the matter was taken up for hearing before Honorable Justice Milord Devanshu Boshak, sitting with my Mr. Shabbar. Milord, that order was passed on 22nd of January 2025. Milord, in the said appeal, their lordship was pleased to direct Milord, that is page 3, Milord, paragraph 6. Sektu Deven. Milord, here also, Milord, the honorable court was pleased to direct Milord the corporation, Milord, the undisputed amount within Milord fortnight from the date of communication of the order. Milord, page 3, paragraph 6. Learned advocates appearing for the read petitioner submits that her client was granted a contract in terms of a tender floated by the appellant. She refers to the award of the tender, the running account bill submitted by her client, as also the noting therein. She also refers to the completion certificate dated April 4, 2024. She submits that there is no dispute as to the claim of her client. Now, Milord, kindly come to paragraph 10, last line. Certified that the petitioners carried out to the work in terms of the work order valued rupees such and such. Thereafter, the appellants also issued a certificate dated April 1, 2024, where the final bill amount of rupees 162,15,311 was acknowledged. The certificate also acknowledges that the bill of the read petitioners was for 74.91 works in terms of the work order. Now, Milord, kindly come to paragraph 12. Therefore, deducting that sum for the bill amounting of rupees such and such, a sum of rupees 10775,311 remains due and payable by the appellants to the read petitioners in respect of which the appellants are not in a position to advance any defense. Milord, here also, Milord, there is a direction. Lordship, kindly have a look to page 5, paragraph 14. Milord, therefore, the sum of rupees such and such remains due and payable by the appellants to the read petitioner uncontested. 17 paragraph, in our view, interest of justice would be subserved by modifying the impugned order and directing the appellants before us to pay rupees such and such to the appellants within a fortnight from date. Milord, following the judgment of Honorable Justice Dipankar Datta, Milord, several Milord coordinate benches, Milord, were pleased to pass the order. If your Lordship, Milord, want to see there, Milord, in Milord, this judgment was passed by Honorable Justice Shompa Sarkar in WPA number 4877 of 21.
I've seen this. Judge.
Milord, considering the entire Milord judgment of Milord Honorable Division Bench presiding over Milord Mr. Dipankar Datta, that was Milord mentioned here and quoted. And accordingly, Milord, Lordship was pleased to direct the respondent corporation, Milord, to pay the amount. Milord, this order was passed on 25th of August 2021. Thereafter, Milord Mr. C. Amrita Sinha also, Milord, passed an order on 10th of October 2023. Take to the bench. So, my lord, in several cases, my lord, their lordships were pleased to pass an order. I don't have all the
Yes.
copies. And in this,
Yes, you have made.
my lord, grateful lordship.
So far as the judgment placed by my learned senior friend of
Beside our representation.
Milord, only one point, Milord. The judgment which has been relied upon by my learned senior friend in Joya Construction, the division bench judgment, Milord will kindly consider this is the single bench of the from which the appeal was carried out in the matter, Milord. Milord will kindly take up para 16 of the said order, Milord. May I place it? Keeping in view the ratio laid down in the judgment cited by the respondent, this court is of the opinion that in the present case there is no clear-cut admitted claim for the court to direct the respondent to disburse the amounts claimed by the petitioners, even if the court could have been lenient in as much as the work done by the petitioners pertains to public work, which has and touch of public law element. In the circumstances as indicated above, it would be dangerous precedent to grant relief as sought in the writ petition such and such without going on the fact-finding endeavor upon the erection of the proper evidence in due course. In such and such dismissed, nothing similar. This order was carried in appeal where Justice, the Honorable the Chief Justice, my lord, will, if my lord kindly refers that order, my lord. There, my lord, the Honorable Chief Justice, my lord, in paragraph 4, I just referred like, it says that thus the ultimate conclusion arrived at by the learned single bench cannot be faulted.
He's not set it aside.
No.
I've seen that.
Rather, he says that there is, his lordship says that there is no fault on the part of the.
I've seen that.
So, my lord, even if there is a direction of consideration, my lord, let that be simpliciter, my lord, without going into the merit, so that
obviously it goes without saying.
So that we have, if there is any counter claim, my lord, our point in Joya Construction was if there is any counter claim, that cannot be adjudicated by the commissioner.
Your case is distinguishable to the extent that here there's an admitted amount.
There is a completion certificate.
So you decide as representation. Take on.
Milord, will only add, Milord, as there are in other judgments also, that if there is any fault on the part of the contractor, Milord, we will
not expressing any opinion.
Milord.
Only one submission, Milord, in Joya Construction, Milord. I didn't
I'm not-
appear on behalf of the writ petitioner, nor Milord in appellate authority.
I am not expressing any.
My lord. Wait, Lord.
Straight on. The petitioner has preferred the present writ petition alleging non-payment of admitted dues. Full stop. It is the case of the petitioner that the respondent corporation issued work order number
No, it is
ये यहाँ से मिलता है।
চলে যাচ্ছি নাহলে My lord, may I have my lord's leave, my lord?
Yes, please.
My lord, obliged.
Issued work order dated 11/7/2024 in favor of the petitioner. Full stop. The petitioner completed the said work. And hence the executive engineer PWD wide memo dated 21/8/2024 issued a completion certificate in favor of the petitioner, admitting the bill amount of rupees 6,21,567, including GST and LW cess. Bracket में डाल देना, including GST and LW cess. Full stop. Learned counsel for the petitioner submits that despite admitting the said bill amount, the respondent authority has failed to release the amount due to the petitioner. Full stop.
Thank you.
Learned counsel for the petitioner draws the attention of this court to the representation dated 8/1/2025. Full stop. It is the submission of the learned counsel for the petitioner that despite receiving the said representation, the respondent neither responded to the same nor has cleared the outstanding amount. Full stop. Learned counsel for the respondent corporation. Respondent? This is the corporation, huh?
For the corporation. Vidhannagar Municipal Corporation.
Submits that the respondent is willing to decide petitioner's representation dated 8/1/2025 within a period of
As your lordship will
within a period of 4 weeks after affording an opportunity of personal hearing to the petitioner. 4 weeks from the date of passing of this order after affording an opportunity of personal hearing to the petitioner. Full stop. In view of the statement made by the learned counsel for the respondent corporation, this court deems it appropriate to dispose of the present writ petition by directing the respondent to decide petitioner's representation dated 8/1/2025 within a period of 4 weeks within a period of 4 weeks from the passing of this order after affording an opportunity of personal hearing. That's it, nothing.
That lordship kindly direct the Miller to, if the it is found Miller that he is entitled to get the Miller payment. So within a
Outcome of the
specific
said
period,
the outcome of the said consideration shall be communicated to the petitioner within 1 week thereafter. Full stop. Needless to state that the petitioner, if the petitioner is aggrieved by the speaking order, the petitioner will be at liberty to challenge the same in accordance with law. With the above direction, the present writ petition is
Miller, kindly add one line, Miller, that if it is found that he is entitled to get the amount.
I'm not giving any finding to that.
Mine. Grateful.
ये judgment से क्या ना ठीक है ये all judgments are pertaining to what contract.
May I get back the judgments or no?
No, I'll keep them. You want?
No. Grateful.
You know, because our High Court, there was a slightly different trend. So I'm just keeping it.
Grateful. Item 72.
May it please your lordship. So my application. Second round of litigation before your lordship, I was constrained to file this application. We had filed a writ application challenging unauthorized construction by the respondent.
Who appears for Rambagh Municipality? Affidavit of service is taken on record. None appears for respondent number 2, 3, 4, 5. Let fresh notice be served upon the respondent.
Malad, I am appearing for the state respondent in this matter.
Give your appearance.
Malad.
Serve them the other relevant authority.
My lord, the last occasion when the order was passed, when this application was disposed of, they also did not appear, in spite of service.
Serve them again. List on. Keep it on Wednesday. They didn't enter appearance even once in the earlier round of litigation. They
There's
never
no-
appeared.
The
Did they appear or not?
no, earlier writ petition was disposed of in spite of them receiving service. I've annexed the order here, which is noted that they have received the service in spite of receipt of service. Kindly look at page 17.
What was the earlier round of litigation? Show me the order.
It's Annexure P3, 17. Challenging illegal construction by the private respondent. The writ petition was disposed of with the direction for inspection, and if it's found that illegal construction is there, there has to be an inquiry. Now, your lordship would come to page 21. The inquiry took place, the hearing took place, and it was found that the construction is illegal, absolutely unauthorized. Page 21, the last portion, page 21 and 22. Oh, correct.
We'll see it on Wednesday.
And then my representation is there at 23.
I'll see.
Nothing, they're doing nothing about it.
Wednesday.
Illegal construction.
Serve them again Wednesday.
Next Wednesday, your lordship. The difficulty is because it has to go to Hooghly.
When do you want it?
Give us some breathing space so we can.
Next or next?
First week of April,
First of April?
yes,
Game 3rd April.
first week of April.
3rd April, Thursday.
Great.
Now 73.
73, my lord, I am for the petition. That this petition has been filed at the instance of the widow of the Mrs. employees who are working on the corporation as a conservancy must do. The terminal dues, my lord, which was due in pay today, my lord, I don't find corporation appearing. So, my lord, if my lord, although, my lord, the affidavit service is there, whereby we have served to all the respondents. But, my lord, so, my lord,
Who appears for the corporation? You must be appearing for the corporation.
Yes, sir.
without troubling the minors.
Decide his application.
Well, I will
Yes,
say, but
yes.
let him alone first say, my lord, in immediate portion I find, he is the housewife of the ex-employee and residing in ward number 42 SWM, Borough 5, is our office. She is residing in our office. I don't know what is their exact address. What is it? What is their address?
What is your address?
Residential address?
She at present, my lord, she is residing at the native place.
So give
Because-
their address.
That address can be incorporated, but sorry, but I said she can live from your lordship, incorporating the address of the petitioner, where now at present residing.
So what is the why is the
But
address is there?
that may not Cost item, Milord, it has been discussed, no doubt about that 405. At present, she is having no address to stay over here. So, Milord, she is at
Give
the
the correct address, sir.
correct, I shall.
এফিডেভিটে ক্রিয়াকরণ করুন এফিডেভিটেই তো হয় না
Alright, counsel for the petitioner takes liberty of the court to
ঠিক আছে, ওটা বলে দেবো।
এফিডেভিটে
to
ক্রিয়াকরণ
amend the cost title and provide the correct address as well as
জেনে নাও দয়া
get
করে
mentioned in
এগুলো বই বলে
affidavit
করিডোরে
filed by
বই বলে কাজ হয় না।
পিটিশন পাঠিয়ে
the petitioner.
হ্যাঁ, ঠিক আছে,
Liberty is
ঠিক আছে, দিয়ে
granted.
দেবো।
Let the same be done within a period of
কবে করবি?
So within 10 days, Milord, I shall back.
within a period of 10 days, list on after 10 days.
ঠিক আছে
Lord, advocate on record of the petitioner is lying ill, kindly grant 2 week time.
Not today. After 2 weeks, sir, 2 weeks now. None for the petitioner. In the interest of justice, adverse orders are deferred.
75 by statement. Last occasion, he is not appear.
Sorry?
Last occasion, he is not, petitioner not yet appear.
None for the petitioner. It seems the petitioner is not interested in pursuing the present petition. The same is dismissed in default.
Any. Minute, I beg to appear for the status.
Well, I am for the municipality led by Mr. Ghosh.
Run for the petition. Well, sir. Lord, the petitioner, Lord, is a retired employee of Hooghly Chinsura Municipality.
Of?
Hooghly Chinsura Municipality. I mean, Lord, his last pay slip, Lord, at page 28, annexed P2.
Yes.
The permanent employee, Lord, everything, Lord, he was getting, all the basic dearness allowance, everything, Lord, he was getting. After retirement, Lord, the authority, Lord, is not issuing pension payment order, Lord, in his favor. As a result, Lord, he is not getting pension. Not also the provisional pension. Now, Lord, what happened, Lord? This the post of pulley, they are the conservancy workers. They are called horizon people. And Lord, their redesignation, Lord, was proposed by the municipality to the director of local bodies. Lord, that is at page 32. And a series of names below, these people are conservancy workers. For redesignation, Milord, these people's name has been sent before the director of local bodies. Your petitioner's name is appearing at serial number 118, 108, 18, page 36.
Serial number?
118, page 36.
Dilip Hari.
Dilip Hari. Now, my lord, a similar types of people, my lord, among this list, they may not file writ petition, my lord, before this Honorable High Court. 9 persons, my lord, have filed writ petition before this Honorable High Court. And, my lord, their pension has been started. And they have also been redesignated as conservancy workers. I mean, I have annexed, my lord, one order, and my lord, there are several other orders also. But these are the orders, my lord. A copy है? हाँ, हाँ, two of them order. One is the order of consideration, another is order of, my lord.
What is the impugned order? Who has passed this impugned order?
No order has been passed.
No order passed. We should be seen cancel status at the letter dated 30th January 2024. Whereas it is not annexed to the writ petition.
Impugned order, no impugned order passed.
No,
What a copy pasted devil.
no, but whatever, I mean, I will get a kuchi, I was looking for this.
Now, my lord, till date, my lord, he is not getting the provisional pension. This is the crux of the matter. I want, my lord, a pension to be started, my lord. That's it. And, my lord, similarly circumstanced people, my lord, are getting pensions.
The present petitioner, along with many persons, were appointed in 80s and 90s by the municipality for the post of they served. Their salary was.
You have seen the orders passed by the court.
We have in all those matters.
Then,
my lord, the problem is, my lord, after enactment of online pension portal, we have seen all particulars of the retired employees. The department, the government department is not accepting their designation because they were appointed as coolie. Now the government has defined that post as conservancy work.
So should they suffer?
Yes, my lord.
They should suffer because of that. Because
That
of
is
your
why the
portal.
government is answerable, my lord. Unless
Yes.
the designation is changed.
Lordship, may I respectfully invite your Lordship to page 17, the prayer clause.
Forget the prayer clause.
No, Lordship, he is asking for quashing of a letter dated 30th January 2024. My lord, that is not annexed, my lord.
Forget the
So I
prayer
was
clause.
not in a position that what instruction from whom the instruction is to be taken, Lordship. What unnecessary prayer be? How do I know from which authority am I to? Because until unless I find this order, you want quashing of 30th January 2024 passed by whom? As because, my lord, I find, my lord, from the coordinate bench order, which my learned friend has annexed at page 52, I find there are two orders annexed. One is at page 52 as the first order. Here from the state government stand, I find at page 53, my lord. May I respectfully invite your Lordship to page 53, my lord?
Yes.
Kindly see the state government stand. It has been submitted by the learned advocate appearing for the state. The prayer for redesignation of the petitioner as conservancy worker has been approved by the Director of Local Bodies by an order dated 21st June 2024, and the municipality has been directed to release the retiral benefits dues of the petitioner, including penalties. This was the submission of the state so far as WPA 5684/24 is concerned. So if that be so, then he should also not have any problem. So I was wondering that what is this order that he wants quashing?
What is that order?
That's
Not
page
annexed to the writ
29.
petition.
Page 29.
You have annexed it?
Yes, yes.
Page
Page 29.
29.
Yes.
That's 611.
Yes, yes.
But in your writ, you have mentioned.
No, it is mentioned 30th January 2024. Clause B, Lordship, prayer clause.
See page 17, clause B. What is that letter?
My lord, there is no such letter.
Then why have you mentioned
My lord, it may be a
Admit
mistake.
that.
Maybe
What
a
is there in
mistake.
that?
It may be a mistake. My lord, there is no such 30th January 2024 order.
Correct the mistake.
Yes.
Correct the mistake.
Yes, yes. There is no such order of 30th January 2024.
Petitioner seeks liberty to amend the prayer clause. Prayer clause B, wherein he states that there is no letter of 30th of January 2024, which he seeks quashing of. Full stop. Liberty is granted.
Lord, here and now, my lord, I will correct.
Liberty is granted. Let this matter be listed on. In the meantime, you seek instruction.
1 week hence, my lord, kindly keep it so that in the meantime. I find still stand is clear in the earlier order.
We'll follow the same
Similar
order. Just keep
But
this order.
similar set of 9 matters are also in listed before your lordship, item number 150 to 158.
This order 568.
We have not reached there, sir.
Stand, the HON'BLE chain was there. 1 week we have already.
1 week.
Lordship.
You seek instruction, direct the local bodies to.
Yes, I am only in this matter.
That's what I'm saying. This
My
is
lordship,
instruction.
sure, sure. Grateful.
Item number 83. 83, my lord, I had private respondent. Yesterday also, my lord, petitioner was not present.
Nobody for the petitioner?
Yesterday also nobody was present.
None for the petitioner. Let this matter be dismissed in default.
Great.
Who do you appear for?
No, in the next matter.
Petitioner?
Which on next matter, not in this matter. 93.
Next matters we'll have it after that.
93 minute. 93 minute I appear for the
93,
petitioner. My lord.
93, my lord, I am appearing on behalf of KMC. I am paying for short Passover.
Passover today, we'll have it on Tuesday. When do you?
That yesterday it was also get adjourned.
Young.
Short Passover.
What do you want? Now you have become slightly senior. Show some grace.
My senior is engaged in courtroom number 35.
We'll have it on Tuesday. Not today.
Monday.
Tuesday.
Tuesday.